up to the speaker's microphone to provide his delegation to the board. Mr. Bell, you will have 5 minutes to speak to the board. I will let you know when you have 1 minute remaining.
Regarding item 11.1 on the agenda. Prior to retiring from the practice of law, I was an assistant Crown Attorney in the Office of the Crown Attorney in Hamilton. I dealt primarily with criminal cases and investigations conducted by the HPS. A great deal of my work involved charter litigation and charter compliance. There has been no motion put before the board which is more important than the one before the board today. Charter compliance is an essential and indispensable part of providing adequate and effective policing. Passing this motion will show that this board is serious about requiring the HPS to safeguard the charter rights of everyone in this city. I'd like to speak first to the educational component of the motion. It is proposed that the board hear from 2 lawyers, one for the Crown, one for the defense, about the sections of the charter which have the greatest effect on police work. By involving both the defense and the Crown, the board will be assured of a balanced view. In addition, you have the perspective of a highly respected reporter, Mr. Steve Buist. Mr. Buist co-wrote an award-winning series of articles on the treatment of the charter by police services across Canada. His comments will be enlightening. What I hope you take away from the presentations is 3 things. First, that the charter is extraordinarily important. Second, that the police fail to treat it as extraordinarily important. Third, that you, members of the board, need to change that. Secondly, I want to stress the importance of the monitoring requirements set out in Section C of the motion. The board must be told of charter compliance failures. It is up to the police to inform the board of them. As the case of Regina against Elawad shows, the HPS lacks effective internal quality control. The police will have to look to people who have the ability to identify charter breaches, Crowns, defense lawyers, and judges. The consequences of charter breaches can be found in the disposition of cases: withdrawals, plea bargains, reduced sentences, stays, and acquittals. The HPS has to track the disposition of cases and find out the extent to which a charter breach played a part. That requirement applies to every criminal and drug charge the HPS lays. It does require a development of new procedures, but the chief and deputies should be capable of creating them. The charter, I stress this, the supreme law in Canada, came into effect on April 17, 1982. And the chief and deputies have spent the entirety of their careers in policing being subject to it. Should this motion be passed and enforced, it will be the first time that the HPS and the board have taken charter compliance seriously. Furthermore, the board has to impress on the chief the importance of reducing the number of charter breaches to 0. It should be part of the chief's performance review and part of the ongoing monitoring of the chief's performance, which is required by Section 37 of the CSPA. Because if the chief doesn't treat charter compliance seriously, unless HPS members, from deputy chiefs to cadets, know that charter breaches on his watch are not trivial slips, but career-limiting failures, The essential cultural change that the HPS must make will not occur. The HPS will continue to regard charter compliance as a secondary consideration, if not a nuisance. Adopting this motion is a step toward making Hamilton a city where no one is illegally searched by the police. No one is illegally detained by the police. No one is impeded in the exercise of the right to counsel by the police. And no one is deprived of the right to a fair and timely trial due to the failure of the police to provide disclosure materials to the Crown. This community cannot trust this board if it is ineffective.
I've been very generous with you.
Thank you. If it is ineffective in safeguarding charter rights. I urge you to adopt this motion. Thank you for the lenience given the chairman.
Thank you very much.
Are there any questions?
Yes.
I beg your pardon?
Don.
So there are no questions about my presentation?
That will be part of what I do. I'm going to ask for a mover and a seconder, and if there are any questions.
Thank you very much.
Okay, can I go ahead with that now?
You don't need my permission.
Can I get a mover and a seconder to receive the delegation? Member Menezes? Member Pauls? All in favor? Okay. Do members have any questions for Mr. Bell?
Thank you. I simply have a comment, which is just thanking Mr. Bell for his delegation. He gave an equally impassioned delegation just over a year ago, last February's board meeting. And I thank you for highlighting the intended balance in my motion of the educational input from both the Crown, defense, and community to be a collaborative learning process for all of us in Hamilton. And I want to apologize that it has taken me so long since your delegation to put forward this motion and compile this motion. It took a lot of learning on my part to learn about charter rights, and I hope we can all continue to learn about charter rights together, so thank you.
Mr. Bell, thank you for coming in today. I had one question about terminology used, career limiting failures.
Yes.
During your speech. Can you expand on that for me?
Sure. I don't know of any disciplinary procedures that were taken against any officer due to charter breaches. A charter breach should be viewed as a scar on a police officer's record. A charter breach should be viewed as an impediment to promotion. And I'm not just talking about the poor constable that messes up because of improper training, guidance, support, mentorship, things of that nature. You have to look to his superior, to the sergeant that's supposed to assist the officer and review the officer's work, to the staff sergeant who supervises the sergeant, to the other people at the higher levels of the service. If they don't care, the community will suffer.
Mr. Bell, what was your... Sorry, you go ahead.
I was an assistant. I was called to the bar on April 5th, 1979. I was appointed an assistant Crown attorney for the province of Ontario on April 30th, 1979. I worked continuously as a member of the Hamilton and St. Catharines offices of the Crown attorney for 32 years. I was an instructor in the wiretap course, which is a highly sophisticated area of law, which dealt with privacy issues long before the charter. I know what I'm talking about.
That wasn't the intention.
No, I know that, but...
Tremendous amount of respect for what you did, and I do understand that you have a tremendous amount of experience, but in your career, did you ever make a mistake, or any of your colleagues ever make a mistake in the moment?
What do you think the answer is?
I would assume yes.
Forgivable mistakes. I hope that you read the decision of the Superior Court of Justice in Elmwood. I think every board member should, and every police officer in this room should have studied it. Elmwood was a scandal. Deceptive, manipulative police officers. Their evidence wouldn't reach a standard tolerable in traffic court. Terrible notes, fabrications, charter breaches, ignorance of the law, a total, absolute failure. One officer was a member of the month. She joined as a cadet. She had 6 or 7 years on before she got involved in that disgusting display of incompetence.
Point being is if we're going to try and work together collaboratively, I think we should approach this all in a way that it is collaborative, right? Otherwise, I think if there's inherent conflict in this, I'm going to struggle.
Well, actually, this sort of, come on, guys, we're all in this together approach will fail. The police only understand that they have to comply not with the charter, but with what their supervisors want. And if the chief doesn't insist on charter compliance, it's just not going to happen.
Are there any more questions? Seeing none. Thank you.
Thank you.